Fourth case on this morning's docket, case number 120924, in the matter of Joshua Matthews. And as you note, Justice Beyer is recused on this case. She's replaced the distinguished jurist on my left. This is Judge Stephen Hill of the Court of Appeals. He's read the materials and he'll be participating in the ultimate resolution of this case. Judge Hill, thank you for helping us out today.
May it please the Court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. Mr. Chief Justice, I would like to reserve 2 minutes for rebuttal.
2 minutes is granted.
Thank you. This is an original proceeding in attorney discipline involving Joshua Matthews. Mr. Matthews was admitted to the bar in 2008. This matter that's now before the Court was heard before a hearing panel on February 21st, 2019. Prior to the hearing, Mr. Matthews entered into stipulations regarding the facts and rule violations. The hearing panel's report was filed on March 20th, 2019. The next day, Mr. Matthews filed a statement pursuant to Supreme Court Rule 212C, stating that he did not wish to file exceptions to the hearing panel's report. Accordingly, the hearing panel's findings of fact are deemed admitted, and the issue before the Court today is determining the appropriate sanction to impose as a result of Mr. Matthews' conduct. The facts are that by June 30th of 2017, Mr. Matthews had not satisfied his CLE requirements for the 2016-2017 compliance period. To remedy this situation, Mr. Matthews on September 8th, 2017, attended 8 hours of CLE at a video replay program in Blue Springs, Missouri, sponsored by the Missouri Bar. While in attendance at that program, Mr. Matthews, however, also viewed 4.5 hours of online CLE courses offered through a company called Lawline. Later, after he left the program in Blue Springs, he completed an additional 1.5 hours of online CLE course through Lawline. Subsequently, on September 11, 2017, Mr. Matthews submitted to the Kansas CLE Commission a certificate that he received from the Missouri Bar showing that he attended 8 hours of CLE, none of which included an ethics hour. Later, Mr. Matthews would submit an official CLE sponsor affidavit in which he mistakenly claimed that the 8 hours of CLE he attended at the video replay session included 1 hour of ethics credit. Finally, Mr. Matthews submitted to the CLE Commission the certificates he printed off from Lawline showing the 4.5 hours of CLE courses he completed while in attendance at the video replay session, and the 1.5 hour long course he completed later that day after leaving the session. In all, Mr. Matthews was attempting to receive 14 hours of CLE credit for 1 day of CLE attendance in violation of Supreme Court Rule 806B, which caps the amount of CLE credit an attorney can earn during a single day at 8 hours of CLE credit. On September 18, 2017, Shelley Sutton, the executive director of the Kansas CLE Commission, contacted Mr. Matthews and asked him whether he watched online courses while in attendance at the video replay session. Mr. Matthews denied doing so, claiming he merely logged on to Lawline website to print out the certificates while in attendance at the video replay session. Ms. Sutton asked Mr. Matthews to corroborate his claim by providing her with his login and log-off times and polling verification from Lawline. About an hour later, Mr. Matthews contacted Ms. Sutton and admitted to her that he had watched the online courses while in attendance at the video replay session. Ms. Sutton directed Mr. Matthews to report his conduct to the Disciplinary Administrator's Office, which he did. Ultimately, the Review Committee for the Board for the Discipline of Attorneys referred the matter for a panel hearing. The Disciplinary Administrator's Office filed its formal complaint against Mr. Matthews on December 27, 2018. Mr. Matthews filed an untimely answer to the formal complaint. Based on these facts, the hearing panel concluded that Mr. Matthews' conduct violated 8.4c, engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation, 8.4g, engaging in conduct that adversely reflects on a lawyer's fitness to practice law, and Supreme Court Rule 211B, filing an untimely answer to the formal complaint. At the hearing, the Disciplinary Administrator's Office recommended that Mr. Matthews receive a public censure for his conduct. Mr. Matthews asked for an informal admonishment. The hearing panel ultimately recommended a public sanction. At this time, the Disciplinary Administrator's Office continues to recommend that Mr. Matthews receive a public sanction for his conduct. I believe this sanction is supported by ABA Standards 5.13 and 7.3 and supported by this court's prior decisions in Re Giardine, 306 Can 88, 2017, and in Re Betts, 289 Can 820, 2009. In Re Giardine involved an attorney running for an elected judicial position who made false statements to a newspaper reporter at a public candidate forum and on an online message board denying that he had ever been arrested and charged in Michigan for misdemeanor possession of marijuana. This court concluded that public censure was appropriate for that conduct. In Re Betts involved an attorney who altered an automobile insurance card to make it look like the attorney's vehicle was currently insured. The attorney was ultimately convicted of 2 misdemeanor counts of failure to provide proof of liability insurance. This court concluded that public censure was appropriate for that conduct. Given that the conduct at issue in this case is similar to the conduct at issue in Giardine and Betts, I recommend that the court follow the recommendations of the hearing panel and the Disciplinary Administrator's Office and impose the sanction of public censure. Unless the court has any questions for me, I would waive my remainder time and address the court again during rebuttal.
Do we have any questions for counsel?
Is this a problem of the false reporting of the CLE, or I'm wondering if someone's at a CLE and obviously they have their computer open, and let's say the person next to them observes this person engaging in work or doing something that is not part of the CLE for the entire day. Is that any different than what we have here? I'm just, how much are we monitoring participation in the CLE, and are they paying attention versus this just being a false filing with the CLE Commission?
Sure. During our closing argument, what the hearing panel ultimately found was the 8.4C violation, the dishonest conduct, was Mr. Matthews' initial denial to Ms. Sutton about watching the online programs while in attendance at the replay session. I would say that if an attorney goes to a CLE and decides instead of he or she decides not to pay attention to the CLE but instead watches Netflix movies instead, they're possibly setting up an 8.4G violation where, you know, that conduct would kind of question their fitness to practice law if they're not going to a CLE and actively, you know, watching that program to maintain their competence.
What was the end result? Did he get any credit for any of this CLE, or just the time that he was there and not the time that was online? What was the...
Ms. Sutton told Mr. Matthews that he would not receive any credit. I do know that Mr. Matthews then attended subsequent CLEs and he was in compliance with the 2016-2017 compliance period by the end of September of 2017.
Any further questions? Thank you, counsel.
Please, the court. My name is Joshua Matthews. Here pro se today. I am the respondent in this action. I'll touch just very briefly on the facts, only to the extent that Justice Rosen's questions kind of went into them. Not that it's particularly relevant or that it in any way changes the outcome or excuses my actions. My understanding or my thought process was that the online or what I kind of thought of as the quote self-study portion of the CLEs and that the traditional CLE programming were really two different requirements. Which is why I had never given thought to the idea that I was committing a violation by getting more than 8 hours of credit in a single day. That said, what happened and what I did was, I think, an attempt to exploit what I thought was a loophole. I rationalized the decision based on the circumstances that I was facing, and I convinced myself that I was acting within the letter of the law if not the spirit. The problem is that as soon as a person looks for a loophole or begins to rationalize a behavior, it's a slippery slope, and it's a very downhill slippery slope. And I've seen it happen with attorneys, and there's a show on CNBC, I think, called Scams, Scoundrels, and something, I forget the name of the show, but you can see how people start with the very best of intentions, and then somebody borrows a little money out of the trust account to cover something, and they know they're going to pay it back, or there's some other violation. And what happens is that those behaviors and those rationalizations over time begin to grow. And your life becomes a rationalization, your life becomes an excuse and a way to try to get by. When I spent my life wanting to be an attorney, like many young people, I think, Atticus Finch was the person that we had seen in film and that we looked up to. And the idea was that this was a respectable and dignified person in a respectable and dignified profession. And the choice that I made and the conduct that I engaged in diminished certainly my dignity and my respectability, and I agree with the charge that it diminishes the respectability of the profession. That's not the career that I want for myself, the life I want for myself, the legacy that I want to show to my children. I'm a domestic attorney, and so oftentimes we're dealing with things like whether a parent is unfit. And I often have a conversation with clients about the fact that just because you're not unfit doesn't mean you're a great parent. The bar for being unfit is very, very low. The bar for the rules of professional conduct are not that high. I don't think it's enough to stay above the law. I don't think it's enough to stay out of that trouble and not violate those rules. There have been a lot of changes in my life in the last couple of years, and certainly this process has been a significant part of that, because I think it was what really made me start to recognize that I was heading in a direction and thinking in ways that, if not checked, were going to get me in trouble. Not that there was anything more serious going on at the time, but I see how that kind of thought process of can I somehow stay within the rules while knowing that I wouldn't be proud to stand here in front of this court, certainly for any proceeding like this, but to explain what I had done. It wasn't clever. It wasn't the person that I want to be, and it wasn't the profession that I want to be a part of. In the prior hearing before the panel, I explained the things the best that I could. Certainly, I made it clear that I didn't deny any of the charges. I had asked at that time for an informal admonishment, my reason being that, unfortunately, the commercial aspect of the practice now is very much ruled by a lot of online information and websites like Avvo and some of these that are not very good indicators to us as attorneys or to jurists, but to the public they make a big difference. And certainly the formal written censure will affect that. But I don't have any legal argument or factual argument for why I shouldn't receive the public censure. The fact is that I did something that I shouldn't have done. And I recognize that that what happens now is that I'm pushed back significantly in terms of what I want to achieve in my life and in my career. But my goal right now is that over the upcoming years that I will be the attorney that I want to be. Certainly in my, I think if anyone were to ask, and I had, I think, some letters from attorneys and things, in my practice, certainly I'm a firm believer in always laying everything out on the table, always trying to do what's best for families, always trying to act in the best interest of the children, who are very often the victims of the disputes between their parents. I enjoy doing that. I really love doing that. And I want the opportunity to continue doing that and to reclaim that dignity and that respectability that I know that I've tarnished through these asks. And so that's all I have to say, but I'm happy to answer any questions that anyone may have.
Do we have any questions of council?
What are you asking us to do? The recommendation, I kind of detected from what you're saying that you asked for an informal admonition at the panel, but you may not really be that strong about it here. And as a practical matter, it's hard to see that there's any benefit to you for an informal admonition, because it's still going to be a published opinion, and I mean the internet's going right here now. And
Certainly.
so what are you what are you asking? And if you're asking for something less than the panel recommendation, why?
I guess I would still ask for the informal admonition, and the very simple reason why is that these websites, I think for a long time now, people have been aware of, for example, the challenges that law schools are facing because of the U.S. News and World Report rankings, and that because of those rankings, they're having to change their curriculum, change their structure to try to meet sort of artificial goals or artificial criteria that have been set by U.S. News and World Report, because if you don't meet those, then you fall into the bottom half of the law schools. That's sort of what we're facing as attorneys right now. And informal admonition doesn't go to all of those places. Certainly if someone wants to go and look for it, they can find it. And this information, if somebody Googles my name, they're going to see that I had a hearing before this court, and they're going to be able to certainly see the outcome. I don't know if transcripts and things get done, but they'll certainly be able to see what happened. The difference is, for myself, for just trying to make a living in this particular economy, if I go from a 9.6 on AVO to a 6 on AVO because I have a published censure, then that certainly affects my ability to earn a living and take care of my family. That said, if that happens, and that happens not because of the decision that either this court or the panel made, it happens because of my conduct, and I recognize that. So that's not anybody else's problem to deal with. While I would certainly be thrilled with the informal admonition for that reason, because it does allow me to better compete in the marketplace, I also understand that this court's job, among many, is to protect the integrity of the profession, and whatever actions are necessary to do that, I expect the court to do.
And you understand that we're not bound, we're not even limited by the recommendation of the panel. We can go higher if we want to.
I do understand that, Your Honor.
And regardless of how we dispose of this matter, the public would be aware of the finding of the panel number 14, where, as opposing counsel indicated, because you've not taken exceptions to this, you're agreeing you falsely denied to Shelley Sutton. In other words, as he put it, you lied to her. That's going to be in the public record.
Yeah, it is part of the public record. I mean, as I explained to the panel, the morning that she called, I was homesick with the flu. She called my office. I woke up. I had a text message from the office to call her, and I did. I don't remember the conversation exactly, and part of what had happened was that while I was at the thing, I had printed off, or not printed really, but saved the PDFs of the certificates all at one time. And so I know that at one point I thought that was part of the problem, was that all of these certificates had been, I'd saved one and then the next and then the next, all within a period of a few minutes. I said that if Shelley Sutton said I said that, poor wording, then I must have, because I don't doubt for a minute anything that she says. So I don't deny it. I don't recall specifically. My recollection is that when I got off the phone and talked to my wife about it, and that I sort of realized what the allegation was, and that's when I called her back and tried to clarify that. But again, I believe that whatever she says is true. I don't know that I intended to lie to her. I really don't know how to answer that, because I just don't remember the conversation. So,
Do we have any further questions? Thank you, counsel.
thank you, Your Honor. I appreciate it.
Unless the members of the court have any questions for me, I would waive my rebuttal.
From your office's perspective, why wasn't a diversion agreement appropriate?
Because of the prior disciplinary history of Mr. Matthews, he had received 2 IAs. The IA letters can be found in Volume 3, Exhibit 9 and 10. He received an IA, I think in 2016, for a 1.1 violation. And then in 2018, about the time all this was pending, he received an IA for a 1.4 violation. That was the 2018 IA resulted from a Missouri case. He received Missouri's version of an informal admonishment in Missouri, and so we applied the same level of sanction in Kansas.
Can you remind me how much time there was between the 2 phone calls with Ms. Sutton?
Approximately an hour. I believe that was in the stipulation and in the hearing panel's finding.
Any more questions? All right. Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.